Here we're about to conclude the lecture on access. I apologize for the abrupt ending to the first access lecture. A problem with the recording required that I edit one last section off. I won't tell you what didn't work or why I thought it was appropriate to use that language, but it's better that I don't have it in a lecture, so we'll move on. Of course, to let you know, the last exam is going to go out to you on Thursday. It'll be due back on Saturday. The last exam will cover only privacy and news gathering torts. I'm not going to test you on access or covering the courts, although I am giving you lectures on those chapters because those are valuable bits of information for you to know from media law. Well, let's move on then. We continue with exemption number 3, matters that are exempt from disclosure by statute, and we finish up with FAA versus Robertson, which is an outlier case, as in it's outside the mainstream. In FAA versus Robertson, a requester sought information on the safety of American commercial air carriers, airliners. And the director, the administrator for the FAA, rejected that request. Mr. Robertson sued, and a federal court held that the administrator's decision would be the equivalent of a statute, and so upheld the denial of the requested information. Now, it's a little difficult to understand because exemption number 3 says there's a statute. In other words, the Congress passed a law saying this information is exempt. And here in FAA versus Robertson, you have an administrator making a decision that a court upholds as being the equivalent of a statute. When you take a look at the case in detail, and we don't have that, it's just an example, you will see that the judge deferred to the FAA administrator because, of course, Congress created the federal executive agency and then granted powers to the administrator. And so the judge concluded that Congress's grant of powers to the administrator made his decision the equivalent of a statute. It's an outlier. We don't have any other cases in which the courts have ruled in this way. So just understand that's out there. Let's move on to exemption number 4 regarding trade secrets, privileged and confidential commercial or financial information. And let me explain it to you this way. I call this in my lectures the magic shag carpet caper. And here you have left Cal Poly. Your family's in the carpet business, so you've left the university, you've gone into the carpet business, and you come up with an idea for a digital shag carpet. You talk your family into developing this new style of carpeting. You go through research and development and the manufacture of the digital shag carpet, and along the way you've had to file reports with federal agencies that regulate workplace safety, environmental impacts, and manufacturing processes. Eventually, after years of research and spending $420 million, you unveil your digital shag carpet. Now, what's neat about the shag carpet is that it uses microprocessors and gives the carpet the ability to rake itself. Ask your parents or grandparents about shag carpeting and the little plastic rake that they would send along with the carpet when you bought it. It also has the ability to act as a room-sized video display with surround sound. Although it's underfoot, it's still a room-sized video display. And it also works as a Bluetooth speaker with really incredible bass. You take your digital shag carpet to an industry trade show and you show it to all of your competitors because you want props for what you've done. One of your competitors is impressed. That competitor, who is impressed but not particularly ethical, could use the FOIA to get information about the manufacturer of your shag carpet. Using that information that you filed with federal agencies, your competitor could manufacture his own shag carpet. Now, because your competitor has not spent $420 million on research and development, he can sell his carpet for much less, undercutting your sales, eventually putting you out of business. So that's why we have Exemption 4. Exemption 4 provides protection for trade secrets and other confidential commercial information. so that you don't have to give your competitors inside information as to what you do to be a success. And trade secret, defined in your textbook, is of course a method or process that's used to gain a competitive advantage in the marketplace. It's not the same thing as a patent. Patents are of limited duration. And once the patent expires, then the patent is free for anybody to use. Trade secrets last as long as they are kept secret. So the formula for Coca-Cola is not patented. It is a trade secret, and so it's kept in a vault in Coca-Cola headquarters in Atlanta, Georgia. Kentucky Fried Chicken, the secret 11 herbs and spices, not patented, but rather a trade secret. Although media reports have indicated that the formula for KFC may now have been discovered in a scrapbook in a private home, but you'll have to look that up for yourself. Exemption number 5, intra and interagency memos. Intra, of course, being within, so we have a memo within an agency. Interagency memos are memos that go from one agency to another, and these are exempt because the government doesn't want you to get premature information about proposals for new policies. They also want to prevent premature disclosure of investigations, because as people in government are kicking around ideas for new policies, sometimes they will come up with really strange, way out, fringe ideas. And then they can work inward, coming up with something that will be acceptable and workable. If initial memos concerning these wacky ideas were made public under FOIA, then we would have stories about how the Energy Department was thinking of using radioactive waste to provide lights for homes, and that would create mass panics. So it's there for that reason. Premature disclosure of investigations. We have a good example in the Karen Silkwood case. National Public Radio seeking information about the death of Karen Silkwood. There was a movie called Silkwood, starring Meryl Streep many years ago. Ask your parents or grandparents. And Miss Silkwood worked at the Kerr-McGee plutonium processing plant in Oklahoma. She'd worked there for a while. At one point, when she was leaving the plant, all the workers have to go through radiation detectors because, of course, they're working with plutonium. She is leaving the plant and she sets off the detectors. All the alarms go off. They grab her, they take her to decontamination, take her clothes, subject her to showers to wash the plutonium. They use radiation detectors to see if she has ingested plutonium, which is a terrible thing. And eventually she is allowed to go home. Miss Silkwood then contacts news agencies and says, look, the Kerr-McGee plant has problems and they're not particularly safe, and there's a risk of plutonium contamination for workers and other people. She's going to meet with reporters and show them all the documents that she's put together. And she's going to a meeting at night with a reporter. She leaves her home but never makes it to the meeting. The next morning, they find her car off the side of the road. It's been involved in, it looks like, a one-car accident. Miss Silkwood is dead. The documents that she supposedly was carrying to the meeting with the reporter are not in her car. And family members say that there is damage to the bumper that wasn't there before she left the house. National Public Radio, which had been looking at the story, sought information from the Justice Department and the FBI about the investigation itself. What were they saying to each other? What did the FBI find out? What did the Justice Department lawyers find out? And the federal court said, no, these memos back and forth are exempt under Exemption number 5. So National Public Radio was not given that information or those documents. And the mystery continues still today. Exemption number 6, personnel, medical, and similar records where the disclosure would constitute a clearly unwarranted invasion of privacy. Now, clearly unwarranted is going to be key here. Not just an invasion of privacy, but clearly unwarranted. The first story we have is New York Times versus NASA. You may remember the Space Shuttle Challenger. It blew up. Eventually, they learned that they launched in cold temperatures. The seals, the O-ring seals of the solid propellant booster rockets failed. Flaming gases pierced the giant hydrogen tank, caused an explosion. What a lot of people don't know is that some of the astronauts survived the explosion. We know this from a couple of things. One, there was an emergency oxygen system that was manually operated. And when they eventually recovered the remains of the astronauts who died when the crew cab hit the water after falling thousands and thousands of feet, they saw that several of the emergency oxygen systems had been turned on. The only way you could turn on the oxygen system was to reach forward and turn a knob. They weren't automatic. So that meant that somebody had to be alive after the explosion to turn on the oxygen system for another astronaut. Second thing was the cockpit voice recorder continued to operate. And so it recorded what was being said in the crew cab after the explosion. The New York Times asked for copies of the recording. NASA said no, and they invoked Exemption number 6. And the federal court said yes, it would be a clearly unwarranted invasion of the privacy of the astronauts and their families to have this recording made public. The court said it didn't want to be in a position of allowing just anybody to have access to the recordings out of concern that it might be used in ways that would be harmful to the families. So that appears to be a pretty reasonable use of Exemption number 6. The second bullet point, the Washington Post and the National Zoo. A giraffe died at the National Zoo. The Washington Post made a request for records, veterinary records of the giraffe, to do a story on the death of the giraffe. And the National Zoo responded claiming Exemption number 6, that the privacy interest of the giraffe would be invaded if it provided the Washington Post with the veterinary medical records. Then we had Terry Anderson. Terry Anderson was held hostage in Lebanon, one of the longest American hostages held in that country's turbulent history. Eventually he was freed. He wanted to write a book about his captivity, and so he asked the federal government, the U.S. government, for information that it had about his captors. And the government responded with Exemption number 6, saying that it would be an invasion of privacy of the people who took Terry Anderson hostage, his abductors. But it said that if Terry Anderson got releases from the people who had abducted him, and they agreed to the release of the information, that the federal government would be happy to give him information about members of the terrorist group. So, Exemption number 6, helpful, sometimes not helpful. But keep that in mind when we take a look at Exemption number 7. Exemption number 7 makes exempt files that are compiled for law enforcement. So the FBI, the Secret Service, the Treasury Department, all these guys who are federal law enforcement, Exemption number 7 makes their investigatory files exempt. Reporters Committee for Freedom of the Press sued the Department of Justice for documents relating to a federal investigation. they wanted to get the rap sheets for many of the suspects who were named in this federal investigation. The rap sheets were available in the states where the suspects had lived. In other words, a suspect might be from Texas, and the rap sheets for that suspect would be available in a Texas courthouse. They'd all been gathered together by the FBI and the Department of Justice. And the Department of Justice said it would be a violation of the privacy rights of these subjects of a federal investigation to provide the rap sheets to the news media. The case made it all the way to the Supreme Court, which upheld Exemption number 7, and the justices talked about the anonymity of dusty filing cabinets. And what they were saying is, we were moving into an age of computerized records, where you could just enter a few keystrokes and it would call up everything you wanted to know. And the justices were concerned about that. They said, yes, the reporters could go to the 50 states and look in those 50 states and get the information, and that would be fine. They would have no problem with that. But they did have a problem with going to the Justice Department and asking the Justice Department with a few keystrokes to provide all the rap sheets from the 50 states. And they talked about the difference between being able to press a key on a keyboard versus having to go to a courthouse and searching through these dusty filing cabinets to get the rap sheets. It's clear that the justices were concerned about the idea of privacy and the threat to privacy of the digital age. So, the Reporters Committee lost that case. But in Justice Department versus Landano, Mr. Landano was accused of a crime. It was a federal corruption case. He sought information about the Justice Department, especially information that would tend to show that he was not guilty. The Justice Department invoked Exemption number 7, saying we don't have to give it to you because this is an investigatory file. But the Supreme Court held in that case that the rights of Mr. Landano overrode Exemption number 7, saying that the Justice Department had to provide that information in the interests of justice. Now, Exemption number 6, clearly unwarranted invasion of privacy. And then Exemption 7C. 7C says the federal government doesn't have to provide records where the release of those records would be an unreasonable invasion of privacy, a lesser standard than the clearly unwarranted invasion of privacy for Exemption number 6. So in both of these situations, the federal government or the Congress, in passing FOIA, had concerns about privacy rights of individuals. Exemption number 7 seems to provide more privacy rights for persons who are subject to federal investigation than Exemption number 6. So kind of keep that in mind. It's not likely that you'll be dealing with federal investigations, but it's good to know about FOIA. All right. Failures in FOIA. Forsham versus Harris. Here, the head of a federal cabinet department entity had requested a study, and she contracted out to a Washington think tank. The Washington think tank undertook the study and then reported to her the results. Forsham filed a FOIA request for the study and its results. Secretary Harris refused to provide them, and Forsham went to court. Federal court there said because the Washington, D.C. think tank had not sent its report to Harris, in other words, they just told her about the results, Harris was not in possession of that report, and if she was not in possession of the report, she could not provide it to the reporter. Kissinger versus Reporters Committee. Henry Kissinger, former Secretary of State, gave his telephone logs to the Library of Congress. Ask your parents, grandparents, or if you know something about history, you know that Kissinger was Secretary of State for Richard Nixon, that he worked on the peace agreement in Vietnam, where the United States withdrew from South Vietnam, and he undertook negotiations with the North Vietnamese in secret. Publicly, he would travel to Paris because he was going on a date with a starlet, or he was living the high life, and in reality, he was secretly dealing with the North Vietnamese. Reporters wanted to see his telephone logs and see who he was talking to so that they could have a better idea of how he conducted the peace talks. But he'd given those to the Library of Congress. In Kissinger, the federal court said Kissinger doesn't possess his telephone logs anymore, and FOIA did not require that the Department of State go to the Library of Congress to get back his telephone logs. In other words, Kissinger is not there, the State Department does not possess his records, and so there is no compulsion on the part of the State Department to get those records back. And so the Reporters Committee loses. The CIA versus Sims Project MKUltra. This was a CIA project that involved, in some aspects, the use of LSD. Timothy Leary famously developed and popularized LSD, a way to expand your mind. Not much was known about this. The CIA was concerned that LSD might be used when enemy countries captured American intelligence agents. They were concerned that these enemy nations would use LSD to break the will of American intelligence agents and force them to confess or provide information about intelligence operations. And so they engaged in a research project that involved the use of unwitting civilians who were given LSD, also unwilling and unknowing military personnel who were given LSD to see what the drug would do to them. The CIA tried to destroy all records of Project MKUltra. A few of the documents survived, and the head of the CIA after Project MKUltra, Admiral Stansfield Turner, learned about this and looked into this and found that most of the documents had been destroyed. In CIA versus Sims, a request was made for Project MKUltra documents. Number one, they were destroyed, and number two, national security, exemption number one, made the records of MKUltra unavailable. Then we have these FOIA suit successes where people have filed lawsuits under FOIA. There were biological and chemical warfare tests in the United States. The military tested biological weapon systems and chemical weapon systems in America, in Alabama, Hawaii, Minnesota, New York, and Washington, D.C. A total of 239 of these tests took place in the United States without the knowledge or agreement of the people who were used in the tests. In Alabama, the military flew aircraft over an Alabama town, and they sprayed from the military aircraft a variant of a pneumonia bacillus, and pneumonia rates went up significantly following that spraying. In New York, agents of the military went into the subway system and, using briefcases that were set up as sprayers, sprayed inside the subways, testing the effectiveness of chemical and biological warfare agents in New York. FOIA was used with success to find out about the FBI's activities during the Vietnam War, where the FBI targeted anti-Vietnam War protesters, people exercising their First Amendment rights to protest against the war, and the FBI looking at them, targeting them, and in some cases actively trying to get them fired or having them prosecuted because of their disagreement with American foreign policy. And perhaps the biggest of the FOIA successes, the radiation tests. This wasn't a lawsuit. This was merely a FOIA request. Now, for years, reporters had made FOIA requests to the Department of Energy about any radiation testing that took place in the United States. But it wasn't until the Clinton administration, when Secretary of Energy Hazel O'Leary responded to a FOIA request from a reporter from an Albuquerque newspaper and released U.S. radiation testing documents. And the Department of Energy documents showed that about 16,000 American men, women, and children, yes, children, were subject to radiation testing. And this is what happened. The Air Force was decommissioning an Air Force base near Albuquerque, New Mexico, and they were handing the facility over to the local government for use for whatever they wanted. One of the things they had to do was they had to gather up hazardous material and dispose of it, because they didn't want the people in Albuquerque coming onto the base, having transformed it into civilian use, and then wandering around dangerous substances. A reporter doing a story on the transition from military to civilian use came across documents that referred to buried radioactive materials on the base. And the materials included clothing and body parts. And so she, of course, was interested and started looking into this. She made a request to Secretary O'Leary. O'Leary said, "Sure, I'll give you the documents," and provided them to the Albuquerque newspaper. Incidentally, the reporter in the newspaper won a Pulitzer Prize for public service. But here's what they found out. The United States government had used, in many cases without permission or even knowledge, Americans to see the effects of radiation. Because at the time, we were in a Cold War with the Soviet Union. And of course, each nation had a significant arsenal of nuclear weapons. And we were concerned that at some point we might get into an actual shooting war, a thermonuclear world war. And we wanted to know what would happen. Would we be able to survive? Would we be able to win such a war? So they said, let's see what happens when we expose people to radiation. The radiation experimenters went to a school in a rural community, a school that was made up largely of poor students from poor families. They went into the school and said, hey, we're going to create this kids club. It's going to be a science club. And we're going to let you guys join the science club, and we'll have lectures on science, and we'll have activities on science. And one of the things we're going to do is we're going to give you a big glass of whole milk every week when you come to the science club. Now, a glass of whole milk may not seem like much to you, but in some parts of the country, being able to afford milk on a regular basis for your kids is something that poor families couldn't do. And so families signed up for this. This was great because the milk would help them grow, contributing to strong bones, to good teeth, and it was a great idea. What the families didn't know and what the children didn't know is that the milk had been laced with radioactive strontium. And as part of the science club, they took samples from the kids as the club went on to see the effects of drinking this radioactive strontium-laced milk. They didn't tell the families, didn't tell the kids. It was just this, we're doing a nice thing for you, and incidentally, we're introducing a radioactive substance into your bodies. One of the questions was whether or not people exposed to radiation would survive. And so in some cases, they went to prisons and they had inmates in prisons serving lengthy sentences agree to participate in experiments. In one case, a prison inmate who had gangrene, he was going to lose his leg. The researchers took him and inserted a slug of radioactive plutonium into his leg, left it there for several days. Then, of course, they had to amputate the leg because of gangrene. They also amputated the leg so that they can see the effects of the plutonium in contact with his body. Other prison inmates were exposed to radioactive substances or ingested radioactive substances. In a lot of cases, they were paid for their services by being given cartons of cigarettes, but they weren't told exactly what was happening. A concern was what would happen on a nuclear battlefield. We had nuclear submarines firing missiles, capable of firing missiles, nuclear missiles capable of being fired at the Soviet Union, and we had nuclear bombers, where bomber crews would fly to the Soviet Union, drop their nuclear bombs, and then, with any luck, make it back to the United States. Well, that means you have pilots flying in a place where there's a whole lot of radiation. In one experiment, the researchers wanted to look at the effects of heavy doses of gamma radiation. Would a bomber crew or a fighter pilot who flew through a radioactive mushroom cloud exposed to gamma radiation be able to do his or her job before dying? They wanted to know how people would function. That meant they needed someone to be exposed to high amounts of gamma radiation to see what happened. So they found a family who had a son, young son, who was dying of cancer. And they made arrangements with the family. We are going to let your son participate in this experiment to help with American interests. We will provide compensation. And so they took this boy who was dying of cancer to Oak Ridge, Tennessee, where the United States has a radiation facility, a testing facility. Put him in a room and then subjected him to gigantic doses of gamma radiation. And of course the boy died. But before he died and even after he died, they were able to get information as to the effects of the gamma radiation on him. And then U.S. service members. We used to do open-air atomic testing. In Utah, in Nevada, we would set off nuclear devices right out in the open to see how to make them better. Well, what happens if there's a nuclear war and you have members of the military who are on a nuclear battlefield? Will they be able to function well? Will they be willing to march onto a nuclear battlefield where nuclear weapons have detonated? Will they follow orders? Will they operate effectively? So for a number of the nuclear test blasts, they send out military personnel, members of the Army, the Navy, the Marines, the Air Force, out into the desert. In some cases, they would go into slit trenches, trenches dug into the desert floor. In some cases, they would put up sandbag fortifications. They'd be behind that. In some cases, they just had them sit out on the desert floor. They would detonate the nuclear device, and then once the nuclear bomb went off, they would order these U.S. military personnel to engage in combat maneuvers. Now, generally speaking, they were supposed to be directed away from the fallout plume. In at least two known instances, wind patterns changed, and so the U.S. military personnel marched into the radioactive fallout plume. In other cases, their proximity to the nuclear explosions, the blast front, the radiation. Well, people in these military units who left the service would have reunions and they began noticing that a lot of people were not showing up. And a lot of people not showing up were either sick with cancer or they had died of cancer. And I said, could this be related to the nuclear test blast that we participated in? And there were congressional investigations. Eventually, Congress paid reparations to the surviving members of these military units. And there was an apology made for having exposed them to the radiation. Finally, St. George, Utah. If you've driven up Interstate 15, going to Utah or Idaho, pass through St. George. It's on the Nevada-Utah border. It was downwind on a couple of occasions of nuclear test blasts. So St. George, little town in Utah, they would set off the nuclear device. In a couple of occasions, the wind pattern changed. Instead of blowing the radiation plume away from St. George, it blew towards St. George. When that happened, nobody contacted the authorities. Nobody contacted the city. So kids going outside for recess and playing on the playground were there when the radioactive fallout was coming down, people going about their business. Childhood leukemia rates in St. George were much, much higher than might be expected. But people weren't warned about this. It was just part of the cost of developing a strong national defense. Well, I say people weren't warned about this. In fact, there was one family that got warning. An official working with the nuclear testing program called his son, who was living in St. George with his wife and the official's grandson, and the official said, you need to move from St. George. So the family did. So one family was warned of danger and told to get out of the way of the radiation, but nobody else. All of this in national defense. We were protecting ourselves from the terrible depredations of the Soviets, who would do all sorts of bad things to Americans. And in protecting ourselves, we did all sorts of bad things to Americans. FOIA is important in that if people know that they're going to be found out, they are less likely to do these bad things. And an important point to note is that none of the people doing this research volunteered themselves or their own families for the radiation testing. It was always somebody else's kids, somebody else's brothers and dads. So their patriotism only went so far. Moving on, the Electronic Freedom of Information Act. This was a recognition of the influence of the internet, and so now federal agencies must have databases of their FOIA available records and online access. And it's been modified over the years, requiring more information to be available online. Presidential records, not part of FOIA, but under the Presidential Records Act, 12 years after the president and vice president leave office, their papers become property of the American people. This act was created in the wake of Watergate, when President Nixon tried to assert executive privilege, claiming ownership of all the records of his administration, so that no one would be able to find out what he was doing when he was president. Well, this act says no, after a while, after 12 years, this becomes public. White House email. Yes, I know emails are very much in the news today during the presidential campaign, but White House email is supposed to be done through a White House computer system, and these emails must be preserved or delivered to the National Archives. So White House staff has to use this White House computer system for government business. Well, let's go back here. Regrettably, the Bush administrations did not use White House computers. In fact, Bush 43, a lot of his administration's emails went through a Republican National Committee email server. And so they were not available. Bush 41, George H.W. Bush, millions of emails from that administration were considered to be lost. Some were recovered through computer forensics. And so emails, the use of non-governmental email servers is something that has gone on for a number of years. And with each administration, it's you have to use the White House computer system. These records belong to the American people. So we will see what happens with the transition from the Obama administration into the next administration, whether or not the White House email system has been used as required by law. Generally, since the introduction of emails, no administration has been 100% in compliance with this system, but some administrations have been less compliant than others. The Privacy Act of 1974, it's here in the Access section. It's not related to FOIA, but it is a result of activities by the federal government. See, the Privacy Act of 1974 comes at the end of Vietnam. And what happens is during Vietnam, with Vietnam anti-war protests, it turns out that a lot of people were investigating anti-war protesters. The FBI, of course, was very keenly interested in anti-war protests, but so was the CIA, and so were the military investigative agencies like NCIS or CIS. Even though the CIA and military investigative agencies are not supposed to operate looking at Americans, here at civilians especially, and Americans in the United States, they were doing a lot of surveillance of anti-war groups. And because it wasn't, we're taking notes, or we want you to speak into the microphone, and we're going to make a movie of what you're doing, a lot of the information came from sources and was heard through closed doors or recollections of meetings after the meetings were long over. And a lot of stuff was inaccurate. There were congressional hearings. The Select Committee on Intelligence took a look at a lot of the abuses during the Vietnam War. The Church Committee, named for Frank Church, a senator from Idaho, learned about these excesses and violations of American law by these federal agencies. As they found out that a lot of the information wasn't particularly good, but it became a part of people's permanent records, the Congress passed the Privacy Act of 1974. And the Privacy Act says you can write to the federal government and say, I want to know what records you have about me. What do you know about me? And if it's wrong, you have the right to ask the federal government to fix it. It also exists to prevent federal agencies from sharing information with each other or disclosing information to the public unless the Act says you can do so. If you send away FOIA records and the federal government doesn't give them to you, you can sue to get them. There are some records that are exempt from disclosure, records by law enforcement, records relating to national security, but others are available to you. Now, if they have something wrong, as I said before, you'll ask them to correct it. If they won't correct them, you can go to federal court and seek to have a federal judge order them to make the corrections. And if they don't make the corrections, or if they haven't given you the records, you're entitled to your court costs. But it's a way of kind of keeping track of what the government is doing. So you can ask them to fix the wrong information. You can sue to force them to make corrections. The exemptions, law enforcement, CIA, Secret Service, and it kind of makes sense if you are thinking bad thoughts about the president and the Secret Service knows about it. They don't want you to be able to send them a letter saying, what do you know about me and my bad thoughts about the president? Same thing for the CIA and for law enforcement. Then we have the case of Wen-Ho Lee versus Department of Energy. Wen-Ho Lee was a researcher at Los Alamos Nuclear Labs, not the one near San Luis Obispo, but the one in New Mexico. And Wen-Ho Lee was arrested and charged with 32 felony counts of espionage. And the allegation was that he was stealing U.S. nuclear secrets to give to China. He was held in solitary confinement for more than a year, not able to talk to anybody. His lawyer was allowed to meet with him 1 hour per week. After more than a year of solitary confinement, he came to court one day, and a federal judge addressed him with respect to these charges and started by saying, "Mr. Lee, on behalf of the federal government, let me apologize to you." And instead of facing more than 30 felony charges relating to espionage, he pled guilty to 2 misdemeanors regarding the proper handling of confidential information. While his case was pending, before the federal judge said that the charges against him were unfounded, there were a lot of stories about Wen-Ho Lee in the media. Stories about his background, stories about his work at the federal government. When he was freed after pleading guilty to the misdemeanors, he said, "Where did this information come from? Because a lot of this information was only held by my employer, the Department of Energy." So he filed a lawsuit under the Privacy Protection Act of 1974, saying the information was in the hands of the Department of Energy. It then became public, which means that somebody had to disclose that to the public, and that's wrong. Eventually, the Department of Energy settled. They paid him a financial amount of more than $1 million in return for him dropping his lawsuit. And several media entities contributed to the Department of Energy settlement because, you see, they had reported the stories that had the Department of Energy information about Wen-Ho Lee. Rather than go to court and have to testify as to who gave up the information and where the reporters got the information, which Department of Energy official, they made the case go away with a settlement. But Dr. Lee proved that you could use the Privacy Protection Act to help protect your privacy. HIPAA, the Health Insurance Portability and Accessibility Act, initially it was created to allow people confidentiality with respect to their medical records. And it was written so that if you went to the hospital or if you went to your doctor's office and you didn't want your information shared with anybody, you would sign a document saying, "I don't want anybody to know this." But then people turned the law on its head, and they said, rather than having people opt out and us keeping their information secret, we'll make all the information secret, and if they want their information disclosed, you'll have to sign a piece of paper saying, "Yes, I want you to give my information to the public." One of the results is that in the old days, if there was a traffic accident or there had been a shooting or anything else involving injuries, we in the news media would call down to the hospital and say, "How are these guys doing?" And you'd get a nursing supervisor or a doctor, and they say, "Well, the person involved in the accident is in stable condition with broken bones or internal injuries, or the person who was shot is in critical condition, having been shot 4 times, or the person who'd been caught up in the house fires in this shape." Well, under HIPAA, we no longer get that information. So if there's a traffic accident, we can't tell you how the person is doing unless the family comes forward and say, "This is how my family member is doing." It also means that if you had a friend who was hurt and in the hospital, you couldn't call up the hospital and ask how your friend was doing. Until same-gender marriages were made constitutional. In some states, if you were partners and your partner was in the hospital wouldn't give you that information unless your partner had signed a form previously saying the information could be shared with you. So it helps to create this system of confidentiality and secrecy. Now, that can be a good thing because it protects your medical information from being disclosed. But it can be a bad thing because we then can't keep track of how good a job hospitals and doctors are doing. Let's move on. Meetings. We have FOIA, which has records. Now we have meetings and the Government in the Sunshine Act. And if it's a federal executive body headed by boards of at least 2 people named by the president, confirmed by the Senate, in other words, your board can have, a lot of people, but if at least 2 of them have been named by the president and confirmed by the Senate, then it's a federal executive body that must be open to the public. For these federal executive bodies, they have to have public meetings with notices and agendas. If the body is going to go into a closed meeting for certain topics, and that's allowable under the Sunshine Act, then the agenda has to show ahead of time what they're going to be discussing, why the meeting can be closed. For closing meetings, there are 10 categories which are similar to FOIA. If a meeting is closed, the Government in the Sunshine Act allows people to sue to either force the meeting to be opened if they hear about it beforehand, or to get a transcript of a meeting that has already taken place if they've been talking about things not covered by the 10 categories for which they can have closed meetings. It's federal executive bodies, and they're important because they deal with federal executive agencies, which affect a lot of Americans. We had a lawsuit in Cheney. Vice President Dick Cheney helped put together President George W. Bush's energy policy. At the beginning of the Bush administration, he was meeting a lot of people for his energy task force. Hundreds and hundreds of people from the fossil fuel industry, oil, gas, coal, and a couple of environmentalists, but a small number out of the total. There was a suit filed to get the names of the people who participated because we wanted to know if Exxon or Halliburton or BP had been giving information and advice in the formulation of the Bush administration energy policy. Because we wanted to see, is it all just people from the oil industry? Are there anybody from environmental groups, anybody from renewable energy? But federal appellate court said the names need not be given because the vice president was not confirmed by the Senate to head up this task force. Oh, going back here, eventually the names came out because somebody leaked the names, and we found out that, yes, in fact, the Energy Task Force participation was dominated by people in fossil fuels. So the policy you would expect to come from that was one that focused on continuing to use fossil fuels and not emphasize renewables or take much consideration of the environment. Access to state records. Each state has its own access laws that are similar to FOIA or Government in the Sunshine. In California, we have the California Public Records Act for records, and we have the Brown Act for meetings. And I've sent you through email from PolyLearn a copy of each statute. Access to campus records. Well, you remember that when you came to the university, you had to sign a FERPA document. FERPA stands for Family Educational Rights and Privacy Act. It was created to preserve the privacy rights of students. And so when you came to campus, you had to sign a FERPA document saying, I'm willing to have my information included in a directory of students, and I'm willing to allow information about my college matriculation to be made public or not. It was created by the family of a couple of college students who were not particularly good at going to college. In the way old days, the bad old days, you would have an exam, you would have a project, and you would turn it in, you'd finish the exam, and a week later, outside your classroom, you would see posted the grades. And they would go from either alphabetical, or they would go from the high score to the low score. And these two guys were always at the bottom. They were always getting the low scores. And they complained to their parents. And they said, we take the test, we get the low scores, and people are kind of, oh, you guys are dumb. And they said, we feel embarrassed by this. So the family went to their local member of Congress and said, this is terrible that our kids are being made fun of because they're getting bad grades, and we think that their privacy rights ought to be protected. So the member of Congress talked to other members of Congress, and this was a concern by some people whose kids were not at the top of the list for getting the best grades, and they passed FOIA to preserve the rights and keep anonymous test scores. So anymore, we don't post test answers or test grades. In fact, in the transition period, students used to come and say, when are you going to post the test grades? I said, I don't post test grades because of FOIA. So now you just have to find out individually. Now, that's probably a good thing. You don't necessarily want everybody to know what you're doing in college. But then people started using FOIA, that is to say college administrations, to keep information about students in other areas from becoming public. You, of course, are aware of this emphasis on Title IX and the incidents of sexual misconduct on campuses, assaults, and rapes. For a while, universities used to say, well, reports of campus crimes are covered under FOIA, so we don't have to tell anybody. Then we had the case of Bauer versus Cont'd. Cont'd was the editor for a student newspaper. You see it in the textbook. Bauer was the head of this administration. And there had been stories on campus about assaults taking place on a pathway between a university parking lot and the university itself. The parking lot was a little ways away. There was a path that people would take and cut through bushes and some wooded area. And there had been 2 instances in which female students walking the path alone had been attacked. The school wanted to know about this, and so they asked for information about these reports of crimes against female students. And the university said no. So the editor sued the university. While the school paper was looking for this information, and before the suit went to court, a 3rd female student was assaulted on the pathway between the parking lot and the university campus itself. A federal district judge looking at the case said FOIA does not apply to crime reports. It's not an educational record. And so that case helped make a strong argument in other states that campuses could not use FOIA to keep information about crime on campus secret, because universities are interested in making sure that you and your parents think of the university as a safe environment. A lot of people think of universities, especially Cal Poly, as being an extension of their hometown or their hometown high school, because we're a safe campus. Well, crime occurs on campus at Cal Poly just as anywhere else. And there are sexual assaults that take place. There are rapes that take place. But under Bauer versus Cont'd, universities cannot hide behind FOIA to prevent the public from knowing about incidents that occur. Now, it doesn't require that personally identifying information be disclosed, but it does require that if you ask how many assaults have taken place on campus, they can't use FOIA to deny you the information. All right, let's move on. California Public Records Act, frequently asked questions. Here you might want to pause some of the slides so you can read them, because some of the answers are kind of dense. Exemptions. Now, you remember that under FOIA, if a record falls under one of the 9 FOIA exemptions, It doesn't mean that they can't give it to you. It means that the information is releasable on a discretionary basis, except for those exemptions that rely upon statutes that make information exempt from disclosure, rules out exemption explicitly. Under CIPA, exemptions simply make release of information discretionary. Agencies are not required to withhold information covered by an exemption, unless, of course, there's a specific other statute that says you can't release this information. This comes up. Can records be selectively disclosed to the public, to some people but not to others? And no. So if you are involved in a controversy, there's something going on in your town or in your county, and you want information because you want to oppose something or you want to be in favor of something, and they won't give you information, but they will give information to your opponents, well, that's not legal under CIPA. So if they give information to any member of the public, then all members of the public are entitled to that same thing. Now, and this is an important thing, you look to see who's been getting this information. And if it has been given to somebody else, then you get it. The exemptions most used in California, they use preliminary and temporary draft notes and other memoranda. This is kind of like exemption number 5, litigation. You can understand that private personal information, of course, with privacy rights of the individuals. Investigative security and intelligence information, kind of like number 7. Confidential information could be like exemption number 4, and then there's the public balancing test, in which they say the public interest is served by not disclosing this record. Now let's talk about the Ralph M. Brown Act. Not Governor Brown, but the other Governor Brown, Governor Jerry Brown's father. So the legislature says that these public entities exist for the benefit of the people, and so they must operate openly so that people can see what they're doing. Applies to legislative bodies of local agencies, so a city, a county, district, school districts, special districts, other political subdivisions, they're all covered by the Ralph M. Brown Act. So here you go. You see that it's broken down further. Sometimes, and this comes from covering government in other states, well, back when I used to be a reporter, is that sometimes an institution, a city council or school board, would deal with a sensitive topic, and rather than deal with it as the city council or as the school board, they'd create this sub-body, let it deal with the controversial issue, and then dispose of it in a regular meeting of the council or the school board. Well, the Ralph M. Brown Act says that if you want to create one of these sub-entities, if you have a quorum of the members of a body, in other words, city council, no, let's make it easier. A school board is discussing sex education. Rather than have a discussion in the regular school board where people will be upset and come and protest, they create an advisory committee on sex education. Now, if a quorum of the school board is sitting on that advisory body, then it is subject to the Ralph Brown Act, and it must be made public. A couple of years ago, we had a controversy on campus about the student success fee. ASI said we don't have to have our meetings open, and ASI is not covered by the Ralph M. Brown Act, but it is covered by the Gloria Romero Act. So here, ASI, other university government entities, they have to be open to the public as well. And some Q&As for the Brown Act. Here's one that comes up often. Salaries. They want to give somebody a raise. Does that have to remain public? And generally speaking, no. It can't be secret. It must be public. The only time they can have a closed session to discuss raises if you're dealing with a union. You're engaged in collective bargaining. If you're dealing with a union and collective bargaining, then those meetings can be in closed session because you're negotiating, and you may be putting something on the table that might be premature to be discussed publicly. But only when you're dealing with the union itself. If you're dealing with an employee, then you can't go into closed session. So if you've got a city manager and the city manager wants a raise and you want to talk about that with the city manager, it has to be in public session, not in closed session. And whenever you make a vote on compensation, that vote has to be taken in an open session. And I apologize for the sneezing. Regrettably, because of the problems with editing, you've just seen a couple of sneezes because this PowerPoint video doesn't work when I go in and change things. When you have a public meeting, members of the city council or the school board or the board of supervisors get documents so that they can know what they're voting on, what they're discussing. When these documents and records are given to the members of the public body, you have the right to the same thing. You can have access to the memoranda, the reports, the public records that are delivered to the body before they have their meeting. Because when documents are prepared to be used by this public body, they become public records under the California Public Records Act. So if they're going to look at a piece of paper in the meeting, then you have the right to the same piece of paper at that meeting or before. Of course, they can charge you under California Public Records Act for copies of the record, and you don't have to wait for the meeting. If the body has put together a packet containing all the information, then you can get it before the meeting takes place. And this is important because if you look at the documents they're going to use in support of a vote for or against something, that allows you to come to the meeting with people who believe the same things you do, to make arguments, knowledgeable and informed arguments for or against something based upon the documents they're going to use. If they spring a document at a meeting saying this report says we should ban all wild parties after 10 o'clock on weekends, well, if you get that report before the meeting takes place, you have time to do research to be able to refute it during the public comment period. And public comment periods are important because they represent public participation in the process of governance. There are exceptions to this material in the packet delivered to members of the body. If they're exempt under the Public Records Act, then they also could be exempt even under the Brown Act. And of course, sometimes they have these secret or eyes-only packets of information delivered to the boards. If they're not confidential under the California Public Records Act or some other statute, then they are violating both the Brown Act and the Public Records Act, and you can sue them for that. What rights do you have under the Brown Act? Well, you have an opportunity to address the legislative body before and during the body's consideration of the term. Now, the body may simply say, we're going to have a public comment period at the beginning of the meeting before we consider this. If they don't do that, then when the matter comes up for discussion, you have a right to address the body. So it's either before, everybody gets to talk about everything, or if they don't have that one before where you can talk about anything and everything, when they bring up the matter, then you have the opportunity to make a public comment. Now, if they've already voted on it, in other words, last month they voted on this policy about no wild parties after 10 o'clock, it passed, then your opportunity to speak has passed. You say, well, last month you did this, I disagree. Well, too bad, so sad, it's too late. It's already closed. Special meetings. Special meetings, special topics, emergency topics, even for those things, members of the public have a right to address the body. And when you are allowed to speak, you're allowed to criticize what they're doing. They can't simply say, oh, I don't like what you're saying, you're criticizing me, shut up. They can't do that. The Brown Act says you get to say things critical. So, difference, regular meetings, special meetings. Special meetings, they can confine the public comment to what they're talking about at the special meeting, which kind of makes sense because the meeting is only about one topic or two topics. You don't want people talking about everything. You want to have the special meeting, public comments addressing the one or two things that the meeting's going to cover. Controlling what people say. It's a limited public forum. Remember, public forums, limited public forums. You can talk about the topics, that is to say, government action. And if you're there to talk about that, you have the right to speak. Now, if the city council is meeting and you stand up and you want to talk about Hillary Clinton or Donald Trump, well, that's not a topic that the limited public forum addresses. And they can say, no, we're not here to talk about Hillary Clinton or Donald Trump. We're here to talk about crosswalks and speed limits. And if you want to talk about the city or city government, that's fine. But we're not talking about these other things. And, see, First Amendment, you get to say whatever you want to say. Now, remember from the section on libel that things that are said during official proceedings are subject to an absolute immunity. So if you say during the meeting, part of the official proceeding, well, you guys are crooks, you guys are thieves, you are embezzlers, that's protected under absolute privilege. And if somebody reports on that, that's protected by qualified privilege. So keep that in mind. Not that I want you to go to a public meeting and make slanderous or libelous comments about people. And you have the right to talk about things they're going to take up in closed session. So if they're going to have a closed session to talk about some personnel action, you can say, look, I think you're going to do this and I disagree, or I agree with you. Closed meeting means that their discussion is closed. It doesn't mean that the subject is closed itself.